Advocate Jiba's affidavit.
Please speak to the volume.
Advocate Jiba's affidavit.
It's still volume 3.
It's volume 3, Madam Chair.
I think it is at paragraph page 8000871, paragraph 210.
871. Thank you, Madam Chair. I've located. Advocate Patohi, if you go back to where it starts on page 00866, do you see that? It starts on page 00866.
The affidavit starts on that page. I do see that.
Now, the next page, at the bottom there, you see paragraph 199, where Advocate Jiba says, I tend now to consider the complaint in the poison matter.
I see that.
Which presupposes that she was dealing with other issues, not so.
That is correct.
Now she goes on from that Roman 7, number 7, that subparagraph under the poison matter, from paragraph 201 on the next page, 868000868. The next page, 800869. She in paragraphs 202, 203, and 204. She's still dealing with the poison matter. Go to the next page, 00870. Appear paragraphs 205, 206. You see that?
I do.
There's also 207 at the bottom there. You see that?
I do, yes.
Now she went on up to the next page from 208, 209, 210, 211. She's still dealing with the poison matter.
That's correct.
On page 00872, 212, 213, 214, it appears that
Council, I think it addresses my question.
does it, Madam Chair?
It does.
I'm elated.
Thank you very much for that clarity,
Indeed.
flowing from that paragraph 199 at sec.
At SEC, indeed.
Thank you.
Now let me take you back to your affidavit. You are on page 146.
Paragraph 146.
Yeah, I'm sorry, my apologies. Paragraph 146, page 61.
That's correct.
You may proceed with paragraph 146.
Yes, so I had started from there, and then we sought to clarify what I had said there. So to the extent that it's necessary, getting back to the Boyson review matter, which I deal with in paragraph 145, I state in 146, in response, Jiba deposed to an answering affidavit. This answering affidavit in the Boyson matter, that is, was, according to Chauke himself, finalized by him. And it's correct, as the honorable panel member explained, the reference to 111 is what we've just dealt with, and that is in particular paragraph 210 and 211 of Jiba's affidavit in the GCB matter, where she is dealing with the Boyson matter, and states in paragraph 211, the HODIS SC team then prepared the answering affidavit, which was finalized by Advocate Chauke and which I signed, and there is a confirmatory affidavit to that effect from Advocate Chauke, which is also filed in the GCB matter. So that was, I hope that clarifies paragraph 146. Moving on to paragraph 147, back to the Boyson review matter. In her answering affidavit, and in response to Boyson's assertion that no statements in the dockets implicated him, Jiba stated, and in paragraph, we quote then from paragraph, from her affidavit in the Boyson review matter, paragraph 16, and that continues on page 062 of my affidavit, and then on to 063, where we quote from paragraph 17 and then 21. Essentially, in paragraph 16, Advocate Jiba sets out reasons why she considers there was prima facie evidence against Boyson in the matter. And then in paragraph 17, she makes particular reference to statements that were made by Ayer, Danikas, and Ndlondlo. And in that regard, she annexed copies of these statements to her affidavit, NJ 2, 3, 4, and 5.
Be so kind to read Advocate Batohi paragraph 17 into the record.
In paragraph 17 of her answering affidavit, Advocate Jiba states the following. Particular reference is made in this regard to the statements made by Colonel Rajendran Sanjeevi Iyer, Mr. Aris Danikas, and Mr. Ndlondlo, from which it is apparent that the applicant is well aware of the information that the respondents have in their possession relating to murder of at least 28 people and the monetary and non-monetary awards claimed by him, in brackets the applicant, for the instrumental part that he played in these crimes. Additionally, Danikas has revealed some of the information that he has provided to the respondents and to the press, and even posted video footage thereof on YouTube. I annex copies of the statements as NJ 2, 3, 4, and 5, respectively.
I will refer you at the later stage to these statements referred to by Jiba as NJ 2 to NJ 5. But for the moment, go to paragraph 21 and read it into the record. We'll revert.
Paragraph 21 of Advocate Jiba's answering affidavit. These are only some of the instances that are referred to in the above-mentioned statements, which were considered together with the other information in the docket before the impugned decisions were made. In this affidavit, I do not intend to detail all of the information that was placed before me prior to me making the decisions in issue. I submit with respect that the aforementioned information is prima facie proof that the applicant was involved in racketeering activities.
Now let us go back to paragraph 17 and from there go directly to the annexures that she refers to, which are contained in your bundle. The first one is NJ2 marked SB1 small b on page 088 of your bundle.
Mhm.
Are you there?
I am.
It is a statement of Colonel Iyer, Rajendran Sanjeevi Iyer. You see that?
That's correct.
Go to the last page of that statement.
Mm-hmm.
On page 090.
Yes,
The date is the 3rd of August 2012,
that's correct.
on which it was commissioned.
That's correct. And apparently signed by Colonel Iyer.
Apparently signed by Colonel I. Go to the next one on page 091, marked SB1 small c,
Mm-hmm.
a statement of Aris Danikas.
Mm-hmm.
Before you do so, the first statement of Colonel Ayer is SB1B088 NJ2.
That is so, Madam Chair.
That is the NJ2 referred to by Advocate Batoyi. And then the second one, jumping the one of,
The one of Danikas.
yes, Danikas. Is unsigned. The next statement, NJ4. In other words, the statement of Mr. Danika's NJ3 is unsigned. The next statement of Colonel Ayer is at SB1D097.
That is so, Madam Chair.
And which one were you referring to?
And may I mention, before we leave it, that it is an additional statement. I was coming to it, but may I mention that this second statement of Colonel Ayer is an additional statement from what he states in the second line of his statement. He says he was approached by the investigation team in order to make this the additional statement, and he makes it as set out herein.
The first statement of Colonel Ayer, if you look at SB1B090, who has commissioned that statement?
It's not clear from the statement as to who has commissioned it.
Is it commissioned though?
In any event, it's not clear whether it's commissioned or not. But what appears here is a signature which comes before the name R.S. Ayer Colonel, where he had purported to be saying, I know and understand the contents of this statement, which presumably was before a commission of oaths, but it's not clear. It doesn't appear in the statement, Madam Chair.
He's signing as a deponent, not as a commissioner.
Indeed.
So my question is this statement properly commissioned?
To my mind, it is not properly commissioned.
The next statement of Colonel Ayer that you referred to is at SB1D098. That statement is properly commissioned.
It appears so, Madam Chair,
Thank
on
you.
page 102.
If you may proceed, sir.
Advocate Patohi. Let me refer you to the second statement before we go back to the first one of Colonel Ayer, the additional statement. Go to the last page where it has been commissioned by a Lieutenant Colonel Richard Ramukosi. You see that?
I do.
You see above that, there is a signature which is presumably that of Colonel Ayer.
Yes, I see that. It says R.S. or G. Iyer next to it, what appears to be Iyer.
Across that signature appears a date, 31 August 2012.
That's correct.
Down the statement, down the page, appears a typed version which says 31 August 2012 at 10:45. And it was
That's correct.
done at Durban.
That is so.
Let us go back to the first one. The first Ayer statement, NJ2, SB page 088. It starts on page 088, Madam Ramachaka, and it ends on page 090.
SB 1B088 for the purpose of the transcription.
Indeed, Madam Chair.
What about this statement?
I'm referring you to the date on which it was allegedly signed, which appears to be 3 August 2012.
That's correct.
Now, tying it to the date on which the racketeering certificates were issued by JIBA, you'll remember that we dealt with it.
We did.
It was the 17 August 2012. Not so. We may
I
refer
can't
back.
recall, but I'll accept. I can't recall.
We may
the
refer
date.
back to the documentation.
Perhaps we could.
I just need to be reminded as to which bundle that was.
Sure.
May I take instructions, Madam Chair? Just
Counsel
for the
behind you.
indulgence. Thank you, Madam Chair. I'm reminded that it appears, the authorization appears, in fact, the application was made on 15 August 2012, and it was in LO3, page LO 00665, where Advocate Chauke had signed above the imprint of Advocate Nokomashilo. You still remember that? LO3 bundle, page LO 00665. That's where the application for authorization in terms of section 24 of POCA was made.
If we're looking for the date that JIBA authorized it.
Yes, we'll come to that. The authorization then comes on page 667. The authorization in terms of section 21F, it's on 667. Maybe I should have
That's
started
correct.
with 666,
That's right.
where there's authorization in terms of section 21E.
That's correct.
Now, the two authorizations were made after the 3rd of August.
They were made on the 17th of August. That's correct.
After the first,
I beg your pardon, the one at LO 00667 is in terms of 21F.
667 is 21F, indeed, Madam
Yes.
Chair.
You refer to E.
The 1E is 666.
That's
And
correct.
both of them were done on the same day by Advocate Jiba, 17 August 2012.
17 August 2012.
Indeed, Madam Chair.
What's the relevance of this date?
The relevance of the date comes into play because Advocate Jiba states in her affidavit that she considered statements in NJ2, which were sworn statements in NJ2, NJ3, NJ4, and NJ5, which are collectively referred to as SB1 in Advocate Batohi's band.
So NJ4 is dated 31 August 2012, which is after the 17th of August 2012, which logically speaking, it's signed, it's commissioned after that. So at the point when the racketeering authorization was granted, this was, if this statement, whether it was taken or not, I can't say, but it was certainly not commissioned. It was only commissioned after the racketeering certificate was authorized.
NJ4 1D097 dated 31 August 2012. Advocate Mutlamunyane. Seems to be a replica of the next statement. And I say seems to be a replica of the statement NJ4 1E 103.
It is, Madam Chair, and at the beginning I did mention that there are two statements, the one with a big font and the other with a smaller font, but they seem to be the same. It's a replica of the first one.
I'm not sure about the fonts. All that I know is that they're all in capital letters.
Maybe I used.
But it's fine, you may proceed. I was just making a point that these statements that I've just referred to seem to be the same when
Indeed.
you look at the contents there.
Indeed, Madam Chair. Now, let's go back to Danika's statement.
It's at SB1C at 91091.
It's not even signed.
Of Mr. Danica. So can you please refer to them properly? They are officers. If you don't know the rank, just refer to them as officer.
I'll do that, Madam Chair.
The public will need to know that you are dealing with police officers here.
Indeed, Madam Chair.
You can refer to him as Mr. Officer Danikas.
It is not clear from his statement here what rank he was, but he only says he was a police reservist. Let me refer to him merely as an officer.
Absolutely.
Chairperson, at the time he made the statement, it states, his statement starts, Aris Danikas, age 41 years old, ex-owner of Tektronix, would like to make the following statement. And then he is, in fact, referred to as a reservist somewhere in the statement.
Yes, he refers to himself as a police reservist. So I'll refer to him as an officer. We don't know his rank.
Yes.
Madam Ramakhaha, maybe you'd like to raise something.
No, I don't want to raise anything. Thanks for giving me attention. Thank you.
So, sorry.
When I went through the statement, I wondered whether he's a member of the public or whether he is part of the police force.
Madam Chair, you may be correct because I'm alerted to this technical aspect of whether he's a police reservist, is a police officer or not. And my learned colleague says police reservists are not members of the force. So we rather call him Mr. Danikas.
You may refer to him as such as a reservist. People will understand that he's not necessarily under the commander of the SAPS. We know what the reserves do, but at least we understand that he was operating, whatever he was doing.
He was a reservist.
He was a reservist.
Thank you, Madam Chair. Advocate Patohi will call him Mr. Danikas, the reservist.
As you wish.
The police reservist.
Mr. Danikas, the police reservist.
Yes. His statement is unsigned, as we indicated.
That is correct.
Is this a statement that Advocate Jiwa said she considered?
That is correct. One of the statements she considered was one that was signed after she signed the racketeering authorization, and this one was not signed or commissioned.
Let's go to NJ5, which is on page 277 of your bundle. It's marked SB11, the next SB11. It's in the bundle, Advocate Patohi's bundle. Yes. It's SB11. It's on
SB 58236. Is that the one?
Let me verify it.
Oh, I beg your pardon. No. I am wrong. I am wrong there. Yes, NG5 is SB 11277.
Yes, from 277.
Yes, thank you.
You will remember, Advocate Patohi, that this statement was referred to earlier in the week, earlier last week, or it was referred to, and
You can remind her that it's a statement of Dlondlo. We dealt with it earlier.
yes, it's a statement of John Law which was dealt with,
That's correct.
and an issue arose as to whether it was properly commissioned.
Mhm.
Go to page SB 11282.
And there.
All we see here are a marking, a cross marking, and a name that appeared to be Matiane or Mtiane. You see that?
I do. Looks like it's B. Mtiani.
So this is one of the statements, it's among the statements that Advocate Jiwa says she considered.
That's correct.
Is there anything that you would like to point out
If we could go back,
on these statements
see if we could go back
to your affidavit?
which paragraph were we at? If you could just remind me.
Paragraph 147 was your last paragraph in relation.
145, 140. That's correct, Chairperson. That's correct.
On page 63.
That is correct. So perhaps it would be best explained if I move on in my paragraph, in my affidavit, to paragraph 149. In Boyson's replying affidavit, he dealt with these statements. And the essence of his reply in respect of these four statements attached by Advocate Jiba to her affidavit in support of her decision to prosecute him for racketeering. And that's important to bear in mind, that these were in support of a decision to prosecute him for racketeering was this. Firstly, two were statements by Colonel Ayer, which we've gone through now. They did not implicate him in any of the offenses indicated in the charge sheet. The second statement was only deposed to on the 31st of August, approximately 2 weeks after Advocate Jiba had issued the racketeering certificates. She did so on the 17th of August. She could accordingly not have relied upon the statements, as she claimed in her affidavit, to reach her decision. The third statement, purported to be that of Mr. Danikas, was not a signed or sworn statement. It was also not dated. And further, the events described in the document, as he said, did not cover the period dealt with in the indictment, except for one event, which he said did not relate to him. And the fourth statement was that of Mr. Ndlondlo, which did not implicate him in any of the offenses. And I should state that when a national director authorizes racketeering certificates, you must have the signed statements, witness statements before you, so that you know that this is evidence, proper evidence that you can take into account for the authorization of a racketeering certificate. In his replying affidavit, Boyson also invited Jiba to file a further affidavit to explain how she could have taken into account information on oath that objectively did not exist at the time of taking the decision, given that it was an unsigned statements, and in one instance signed after the date of the authorization. In this regard, Advocate Jiba did not file a further affidavit. However, we earlier went to documents. Advocate Chauke did provide Advocate Hoders SC, who was briefed by the NPA to act in a potential appeal. Advocate Chauke did provide Hoders SC with a memorandum setting out the response, I should say a proposed response to Boyson's replying affidavit. And a copy of this memorandum is attached to my affidavit as SB2.
Go to SB2 on page 111, 111.
Of what?
Of Advocate Patohi's bundle.
It's attached to my affidavit, Chairperson.
Please help me. Take me to SB2.
As SB2, Madam Chair, is on page 111 of Advocate Patohi's bundle. These are attachments to her affidavit. 111.
SB2. SB2,
with a number bolded just on the right hand, top right hand page 030. It's not significant, but it may assist in.
you see, I'm getting
Locating.
confused, Council, because you refer me to 111. If you can read the entire reference, because it's going to be captured in the transcription, as you call it. It's better to read it as is, SB2111. Then we know where we are. Thank you.
It's SB 2111.
I'm there, Council. Thank you.
Fine. Deal with it.
So,
From at paragraph 5 to 8.
so this is an internal memorandum that's from the Cato Manor prosecution team. It's dated 15th August 2013, and it is what appears to be a proposed response to Boyson's replying affidavit that I just talked to, which questioned how Advocate Jiba could have taken, in essence, non-existent evidence because of, I mentioned the reasons. There was no replying, there was no affidavit filed by Advocate Jiba after that, but this appears to have been a proposal to respond to Boyson's replying affidavit. You look at this between the tram lines, it says Boyson's versus ANDPP, replying affidavit of Boyson. And then it goes at paragraphs 1. It appears to be a document that is responding to a filing, and that is Boyson's replying affidavit. And it appears to be, well, it is addressed to Advocate Hodes. So these are proposals in terms of responding to Advocate Hodes.
Go to the next page, SB 2112.
Is it correct, Council, to say that this internal memorandum sought to address the replying affidavit of Colonel Boyson's?
Madam Chair, it was, from the face of it, it was addressed to Advocate Lawrence Hodes SC, who was representing the National Prosecuting Authority in the Boyson matter. It sought to give him responses.
What I'm saying is, when you look at the words in the tram lines, it sought to address Colonel Boyson's replying affidavit.
Indeed.
Thank you.
See to the next page. Look at paragraph 12. Can you read it into the record?
At paragraph 12, it says, the evidence under oath is the evidence in the dockets.
Go to the bottom of the page and read into the record at paragraph 19 to 21.
NJ2 is a statement of ire taken on 3rd of August 2012, stating the managerial responsibilities, participation, and inferences and interferences, in activities of a section of Durban Organized Crime based in Cato Manor. This section, under management and supervision of the applicant, committed horrendous pattern of criminal acts. This statement was obtained before the 17th of August 2012, being the date on which the certificate was authorized. NJ4 is a statement of ire taken on 31 August 2012, following a consultation with the prosecution team. Whatever is contained in this statement was already information related to the prosecution team by the deponent during the consultation with the prosecution team. Therefore, the applicant's affirmance are unfortunate, unfounded, and misleading.
Can you comment? Do you have any comments? Are you able to comment, if any? Advocate Batohi?
My recollection is that Advocate Jiba mentioned that she had considered statements under oath, and this was one of the statements that she considered. In fact, she filed it as attachments to her affidavit. And what appears here is that the statement wasn't signed because they had had a consultation with the witness, but so it was information that the team had. That's essentially what they are saying here. But the reality is that it was still not signed at the time. It was not a statement under oath at the time the racketeering certificates were authorized. I think that's the point to be made here.
I just want to take you back to the respective statements that you have referred to in your evidence, and those statements are NJ2, 4, 5 that appear on SB1, 1B, 1C, 1E. Now, what I'd like to ascertain from your good self is whether you have had sight of the application for authorization of the racketeering certificates. That is, whether you have had sight of the papers that served before the court when the applications were done.
The applications for authorization was made to Advocate Jiba, so I'm not sure which court is being referred to, papers before the court.
The papers that I'm talking about, it's the application papers to the court in order to obtain the racketeering certificates. Those are the ones that I'm talking about.
There was no application to the court to obtain racketeering certificates.
Might I just
Please,
assist
Chairperson.
there? Remember, this was a review application by Colonel Boysons.
That is correct.
Challenging the authorization.
That is correct, Chairperson.
And that is why we have that replying affidavit by him attacking the statements upon which Advocate Jiba relied.
That is correct, Chairperson.
When she issued their racketeering certificates. Am I correct?
That is correct.
I suppose my sister is referring to that review application, because that's the only court application that was there.
If I could then have the question.
That is correct. Thank you. Yeah? Yes.
So if I could have the question then. If I read which papers?
The papers of the application.
I have not read the full papers of the application.
Okay. That's fine. Thank you.
Advocate Batohi, you, after reading the paragraph that you've just read, at paragraph 19 to 21, you said the essence of this paragraph is that when Advocate Jiba signed the racketeering authorization certificate, she did not have signed affidavits before her. But
That is correct.
If one were to look from NJ2 to NJ4,
Mhm.
one of them was signed and properly commissioned.
That's correct. I think one of them is. I
Yes,
think it's Aya's first statement.
Yes, I think we should be careful not to make sweeping statements as if everything that served before Advocate Jiba was not properly signed and commissioned. One of them, at least we know, Aya's second statement was commissioned.
Certainly, that was not my intention at all, because evidence has been led already that there was one signed statement. The point I wanted to make, which is important, is that out of the four, one was not signed and one was signed after the racketeering. The other two, of course, by implication, but in future I will give a fuller answer so that it doesn't appear that I'm highlighting certain things and not dealing with it in a comprehensive way. So thank you for that.
You scare me when you say in future.
I think I'm going to be here for a long time.
Thank you.
Thank you. Is it compulsory for the statements relied upon for issuance of the racketeering certificates to be signed? Is it compulsory for
Absolutely.
such statements to be signed?
Absolutely, because you are dealing with evidence
Mhm.
and you are authorizing charges. So you need to make sure that you have the evidence before you. It's confirmed by the witness. So that is extremely important to have signed statements under oath, affidavits, when you make these decisions, because they have implications.
Right. Is it permissible for, amongst others, to consider hearsay evidence in such applications before a determination is made? Can there be reliance on hearsay?
In any criminal case, hearsay evidence can be admitted in certain circumstances. When you are dealing with an application for an authorization like this, you would consider all the evidence that is before you. I think the important aspect here is, of course, there may have been other evidence that's hearsay in this docket, I'm not sure. But I think we need to, and counsel must help me to go back to the place where Advocate Jiba says that these were statements under oath that she considered. And that is the challenge, because one was not signed and one was signed after the date of the authorization.
Thank you.
As you proceed, counsel, from that page, SB 2114, you will notice a repeat of each and every page that follows, almost up to the end. It just made reading very cumbersome. 114 is repeated, the next one, all those pages. So as you jump the pages going to paragraphs, bear that in mind.
I will, Madam Chair.
Recap and then take you where you were, counsel. Advocate Batoyi had just addressed the response of Colonel Boysons are taking the statements he had just attacked the statement of Colonel Ayer. And I think the next part that you were going to deal with was his response, in which he attacks the statements of Mr. Danikas at page SB 114. If that helps.
It does, Madam Chair. Now, go on to the statement of Danikas. Mr. Danikas, who was a police reservist. The police reservist, the team is dealing with paragraph 22 to 25 of the replying affidavit on page SB 2114.
No, it's not a team. It is the memo that makes reference to the replying affidavit of Colonel Boyson's in relation to those statements. I just want us to capture it correctly. Paragraphs 22 to 25 is the response or the reply of Colonel Boyson's. And he is there dealing with the statements of Mr. Danikas. I think if you can capture it that way so that we avoid the confusion.
Madam Chair, maybe we should, let me take you back to page one, the first page of this memorandum, SB 2111.
Yes.
It's a memorandum addressed to Advocate Lawrence Hodes SC from the Katomana prosecution team, in which they were seeking to give responses to the replying affidavit of General Boysen.
Yes, thank you. I hope I understand. Who is speaking in those paragraphs, at paragraphs 1 to 4, at paragraphs 5 to 6? Who is speaking there under those paragraphs? I may be mistaken.
We assume what is speaking is the team, the Katomana prosecution team, because on page SB 2131, it says kind regards Katomana prosecution team, which will be the team that is giving instructions to Lawrence Hodes SC.
And the team is responding, replying to something.
They are responding to the replying affidavit. It says here in between tram lines.
Yes.
I stand to be corrected, Advocate, but he can help.
Yes, please, let's get it correct.
Between the tram lines, it says Boysen versus Acting National Director of Public Prosecutions, replying affidavit of Boysen. And this memorandum is from the Katomana prosecution team.
Yes, that's correct.
They are seeking to give answers to Advocate Lawrence, who's on brief, representing the Acting National Director of Public Prosecutions. In the Boysen matter, in which General Boysen brought a review application in the High Court, seeking to review and set aside the two racketeering certificates issued or authorized by Advocate Jiba, the Acting National Director of Public Prosecutions.
If I understand you correctly, and you may be correct, that the team seeks to address the averments in the replying affidavit of Colonel Boyson's.
Indeed, Madam Chair, and bearing in mind what Advocate Jiba, I'm not wrong, was the first respondent in the Boyson application, review application, did not file a further affidavit.
Give me a second. Let me just reflect it correctly here. I might have misunderstood the contents of this internal memo as to who is speaking there. Yes, I see at the end, it is signed by the Katomena prosecution team. Thank you for clarification, Counsel. may
Thank you, Madam
proceed.
Chair.
Advocate Baloyi wishes to something.
Just in passing, we are aware that the respondent in an application may not file any further affidavits without leave of the court. The fact that Colonel Boyson invited Advocate Jiba to file further affidavits is not a given because she had to seek leave of the court.
Indeed.
Thank you.
That is so.
If I may, Counsel, if we circle back to paragraph 210, and that is the answering affidavit of Advocate Jiba, which we dealt with earlier, Chairperson, at LO00871. The point here being that at paragraph 210,
Yes, Advocate Batoyi.
thank you, Chairperson.
Paragraph 210.
The only point I want to make here is about Advocate Chauke's role in the engagements with Advocate Hodes. And again, to indicate that this does not suggest simply a coordinator. It's the DPP in charge of the matter, and Advocate Hodes, Advocate Chauke is a liaison person between Advocate Hodes, SC, and the prosecution team, and will provide him with all the facts and evidence necessary in order to prepare, in this case, an answering affidavit. So I just wanted to cycle back to that, Chairperson, to indicate his role in this process.
Yes, thank you.
Now proceed to deal with the next paragraph under the subheading, the statement of Danikas.
So where are you? Which
On
document?
page
I beg your
SB
pardon?
2114 in your bundle.
Yes, I'm there.
You may read the first paragraph there.
These paragraphs refer to NJ3, which is Danika's draft statement. The applicant's averments in these paragraphs are deliberately misleading or misleading due to lack of information. Danikas was reservist in Durban Organized Crime Unit based in Cato Manor. He was recruited into the reservist component of SAPS by the applicant. He was the confidant of the applicant and a family associate of the applicant. The draft statement deals with the activities of the applicant as a director of the KwaZulu-Natal Organized Crime Unit, actively involved in the operational activities of Cato Manor-based section of the organized crime.
Before you do that, and I beg your pardon if I go back to this document, this internal memo, the team responded to the averments under oath by Colonel Boysons, and the memo sought to advise or to provide information to the SC.
That seems to be the case, Chairperson. That's correct.
Thank you.
Proceed to read the first sentence.
Sorry, I turned my page. Could you just direct me, please, to the page again?
Yes,
I get it. 114.
SB 2114.
The second paragraph. The draft starting with the draft statement.
Yes.
The draft statement details the method of operation by the Cato Manor section, with the applicant involved in killing suspects and the applicant condoning and or covering the same.
Now, Advocate Batohi, is it
Just for the record, I'm sorry, just for the record, for those people who do not know who's this applicant will be Colonel Boysons.
indeed will be Colonel? He was Lieutenant Colonel at the time, I believe. I'm speaking under correction, but I'm told he was a Major General then at the time of
He was already promoted. By that time,
apparently
was he already promoted?
Major General, yes.
Major General.
No. May I proceed, Madam Chair?
Proceed.
Now, in terms of prosecutorial processes, should an NDPP in the position of Advocate Jiba, in an application for a racketeering certificate, rely on such a statement a statement which was not on oath, like the one of Mr. Danikas, the police reservist?
Remember, this is not hearsay evidence. This is evidence meant to be evidence under oath, and it's not signed. That being the case, you should have a signed statement so that you know the evidence. The witness is indeed committed to a statement and will testify according to the statement. So the short answer is no. You should have a signed statement, and you should not act on an unsigned statement. In fact, evidence will reveal that Danikas never signed an English statement. I believe there was a Greek statement that at some point.
May I proceed, Madam Chair?
It's just something's troubling my mind. The internal operations within your office operate under the legislation, the NPA Act, of course, the Constitution, the NPA Act, and other pieces of legislation, as well as the policy directions.
Absolutely, Chairperson.
Will this aspect regarding reliance on signed documents or statement reliance on statements under oath be a polycentric matter?
Chairperson, I can't recall precisely the wording in policies, but I have no doubt that there will be something in our policies that will guide our exercise of discretion in making decisions of this nature. We can certainly have a look at the policies. And
Advocate Mohlamoyane, your team will assist us and look into the policy direction documents if it addresses the point that Council is dealing with now.
As a follow-up, what do you make of the provision in the Act, particularly Section 2, that allows the court to act on the strength of hearsay evidence?
Section 2 of which act is, I don't have it in front of me. If I could be given, I did indicate earlier on when I was asked by Madam Ramachakha about hearsay evidence. And I did respond that in any criminal case, hearsay evidence is in certain circumstances admissible. And that would be my response, is that in certain circumstances, hearsay evidence is admissible. In this case, we are not dealing with hearsay evidence. We are dealing with evidence that purports to be direct evidence by witnesses, but not signed. It would not, in my view, amount to hearsay evidence.
To seek to address in relation to the signing of statements purportedly under oath is the probative value of such statements.
Well, Chairperson, it's not a statement. It's not a statement under oath. And the point here.
I am trying to add to the point that you are making.
Mhm.
If you can listen to my proposition.
I certainly will. And my apologies.
That the issue relating to the signing of the statements, as you suggest, that the head of the NPA cannot and should not rely on an unsigned statement. And I'm saying to you, that could be supported by the fact that that statement may not have any probative value.
That is correct, Chairperson.
Let me take you back to your affidavit. You were on paragraph 150, not so, on page 64.
That is correct.
The memorandum SB2 has been dealt with. Proceed to 151.
Following that, Govan J., who was the judge in the review application, set aside the racketeering authorizations, concluding that the decisions were arbitrary, offend the principle of legality and therefore the rule of law, and were unconstitutional. Since there was no material which was considered by JIBA on which to rationally authorize a prosecution of Boyson, the just and equitable consequence was to review the impugned decisions and set them aside.
And that is, I beg your pardon, madam.
I beg your pardon. No, I was just said, and that was what happened in that matter.
Yes, thank you. Sorry to interpose. Are you deliberate, Advocate Mohlamoyane, not to go to SB 2116, the statement of Ndlondo. The unsigned statement of Ndlondo. Is it intentional that you do not go to it?
No, it was not intentional. I had thought we dealt with it, but I may continue to deal with it as set out in this memorandum. Go to page SB 2116.
Sorry, before the witness goes to that, I think on the first day or first or second day that the witness started giving evidence, we were informed, I think, by the Chauke team that they have the last page of the Ndlondo statement that was correctly commissioned.
That is still the case.
And I had hoped that you will share that page with us so that our record is complete. Because as it is now, we still refer to it as uncommissioned when you have a page that is properly commissioned.
We got it from them. When we asked for a disclosure of documents, they gave us the assignment. The problem is that that statement appears maybe 3 or 4 times on the record. And then in some parts, it has the commissioner's certificate.
Just for direction, I remember that. And I think Advocate Nkabinde is correct that they have been supplied, as we are, with this document from the NPA. This correction should be done by the NPA and make sure that we do have that last page. I see the junior counsel is having a conference with someone from the NPA. Please make sure that you follow up on this point again, because it was dealt with last time and the junior counsel was sitting here. This document ought to have been presented to your counsel or to us through the evidence leading team. I suppose that the document will be obtained and be placed on record appropriately. When copies were made, they might have missed that page, but your counsel doesn't have it either. So the evidence leader must have that document and present it to us. May we then proceed?
Proceed, Advocate Patohi. We are on page SB 2116.
I beg your pardon. Yes, I'm there. What would you like me to proceed with?
Deal with the statement of Ndlondo.
That's on SB 2116, the statement of Ndlondo, at paragraph 26. NJ5, which is Ndlondo's statement, gave a breakthrough in the killing of members of Mapumulo Taxi Association by the Cater Manor unit under the management of the applicant in the Cater Manor section, was used by Stanger Taxi Association to kill its rivals, being Mapumulo Taxi Association. Further, Cater Manor section received gratification for this discourse. The statement is hearsay as a direct link of the applicant, but the first respondents had information which corroborated this hearsay against the applicant, and that information has subsequently been converted into evidential material directly linking the applicant. Hearsay evidence is admissible in law, and it is the responsibility of the trial court to determine the admissibility of any hearsay material.
Would you like to comment, if any, on the statements made here?
No, it appears from what is being said here is that the evidence of Ndlondlo is hearsay, but that, as the team states, it is admissible in certain circumstances, but that it is hearsay at this point.
If I may, bearing in mind that the proceedings here are inquisitorial and the documents presented to us as we gather facts, the standard regarding the admissibility of documents in court need not necessarily be the standard in this inquiry. I just want us to get it right. It can be a matter of argument, but I think the terms of reference and the procedural rules of this inquiry makes that clear, that the inquiry proceeds as an inquiry and it is not accusatorial by nature. Meaning, as I understand this evidence, that the evidence which could have been inadmissible in a court of law may be admissible or may be considered here. Am I right?
That is the understanding, Chairperson.
And I deliberately ask you this question because you are a seasoned lawyer, a witness who is a seasoned lawyer.
Not a seasoned witness, though, Chairperson.
Well, you are going ahead of me.
It's my first time, actually.
So I asked you this question because as the head of the NPA, you'll probably know better.
Thank you, Chairperson. That is my understanding as well.
Madam Chair, it's 5 minutes before 4. I wonder whether we can.
We're dealing with prosecutorial response to the Danika's statement as dealt with by Advocate Colonel Boyson's name.
Yeah,
Danikas.
and as well as
Mr. Danikas.
yes, in the internal memorandum.
Internal memorandum in relation to the statement by Mr. Danikas.
That's correct. But we then went to Ndlondlo.
To Ndlondlo.
Yes,
Yes.
on page SB 2116.
116. Thank you. 116. Shouldn't you, counsel, exhaust this item, the memorandum? Are you done with it? Because I don't want us to leave it hanging and we reconvene and you go back there. Let us exhaust the point that we are making here in relation to the response by the prosecutorial team in that internal memo. I suggest you proceed unless if you have exhausted it.
Let- Madam Chair, I haven't exhausted the memorandum. Maybe I should deal with at paragraph 29 on SB 2119. Go to SB 2119, Advocate Batohi.
SB 2118. SB 2118, paragraph 29. Is that the
Paragraph
one you are
29,
dealing with?
yes.
Are you dealing with paragraph 29, counsel?
At paragraph 29, Advocate
Yes.
Batohi, SB 2118. SB 119 is a duplicate of SB 2118.
I propose that we follow the even numbers rather than the odd numbers of the duplication. In that way, we won't be confused. The even number, referring to paragraph 29, at paragraph 29 is SB 2118. Then we will jump all the odd numbers and go to even numbers.
Are you there, Advocate Batohi?
Yes.
Proceed and read at paragraph 29.
First and second respondent were in possession of the statements of the witnesses herein referred to before 17th of August 2012. NJ4 is a further statement of ire obtained after NJ2, which was obtained on the 4th of August 2013.
Do you have any comment on that?
No.
Let's proceed then to deal with.
Just remind us who was the first respondent and who was the second respondent.
Chairperson, I don't have the filing in front of me, so I think the first respondent was the acting National Director of Public Prosecutions. I'm not sure who the second respondent was in this matter.
May I assist in that regard?
Yes, it is the review application by Major General Boyson. So the respondents there would have been Advocate Jiba and someone else. So when you speak to these documents and refer to first respondent, anybody reading this record may not know who are these people. But we are advantaged because we have read the application. So if you can just clarify that.
The application appears in LO4 bundle, page LO00949.
You can just assist Advocate Batoyi just to refer to who is that first respondent and the second respondent.
The first respondent is the acting National Director of Public Prosecutions.
Yes, that's correct.
The second respondent is the Public Protector. Oh, I beg your pardon. Maybe the day has been long. Public Prosecutor. My apologies. My eye ran over the word.
Who is the public prosecutor? Do you know Advocate Batoy, as cited in the review application?
Chairperson, no, I'm not sure.
We do know, however, that the first respondent there was Advocate G.
At the acting national director, that is correct.
Yes. Thank you. You may proceed, Council.
Go to page SB2, 120. At paragraph 30.2. Can you read that into the record?
The applicant seems to concentrate only on the statements of Ndlondlo, Ayer, and Danikas as the only information that was considered in taking the decision to prosecute him. The first and second respondent had further material in their possession to consider before 17 August 2012, which is the monetary award for the Cater Manor unit, including the applicant, motivation of which was drafted by the applicant, and court papers relating to the interdict, case number 13759/2008, against KZN MEC for Safety and Security and others, filed by Bongani Elphys Mkhize, who is the deceased in count 20 on the indictment, where the deceased was seeking court recourse to prevent the police from killing him, which they subsequently did in breach of the court order. The applicant filed an answering affidavit on behalf of the SAPS, marked NJ6. In this replying affidavit, the applicant demonstrated his intimate knowledge and participation in the investigation and subsequent killing of members of the Kwama Pu Molo Taxi Association, the rival of Stanger Taxi Association.
Leave it at that. Go to page SB2 122 at paragraphs 31 to 36 and read the first paragraph there.
The applicant bases these averments on misleading allegations that we did not have information, namely NJ2, 3, 4, and 5, which we have demonstrated by dates and months that we had these sworn statements and information before the 17th of August 2012. And further, that we had the monetary award documentation as well as the applicant's answering affidavit. The applicant further bases these averments on the information that the information has no evidential weight, which we respectfully differ with and is a matter for the trial court to determine.
That there were sworn affidavits and information before the 17th of August 2012. Is that correct? Is that a correct proposition?
That is correct, according to what they say in this paragraph.
I mean, vis-a-vis what is contained in,
yes, sorry,
in documentation.
When we look at this, it says
before the 17th, bear in mind that the 17th of August was a date on which the racketeering certificates were authorized.
Understood. This states, namely NJ2, NJ3, NJ4, NJ5, which we have demonstrated by dates and months that we had these sworn affidavits and information before the 17th. Now, we do know that at least two of these were not sworn affidavits at the time before the 17th of August 2012.
May I then refer you to, I leave the internal memorandum for the moment, Madam Chair, and refer the witness to LO4, page LO00949, referred to earlier, which contains the first and second respondents answering affidavit, being the acting National Director of Public Prosecutions as the first respondent and the Public prosecutor. And specific reference is made to page LO4, LO00959.
LO4 page.
Page LO4, LO00959. LO4, I was not on speaker. LO4, LO00959. Specific reference is made to paragraph 24.5.
Thank you, Counsel.
Advocate Batohi, this is an affidavit proposed to by Advocate Jiba. It ends on page LO4, LO00976, where Advocate Jiba has signed the affidavit. You see that? It appears that it's her signature, apparently her signature that appears there on.
That is so.
Now, if you go back to LO4, LO00959, you'll find paragraph 24.5, which I ask you to read into the record.
The applicant has failed to demonstrate to this court in what respects the decisions sought to be impugned are unjustifiable, irrational, unreasonable, or unlawful. He is directly implicated under oath in the statements placed before me in annexes NJ2 to NJ5.
Now, this page will later be handed up as an exhibit. Is this statement correct?
It is not correct because we do know that at least 2 of those statements were not under oath.
Which ones?
It was the second one of Iyer and the one of Danikas. The one of Iyer signed, I think, on the 31st of August.
The one of Iyer, it's on page, signed on 31st August, it's on page, it's SB 1D, NJ4 on page SB 1D 097. SB1D 097, that's where it starts, and it ends at SB1D 102, where there is a signature there, or 2 signatures.
Take me to that document again, Counsel. I'm sorry to take you back.
SB1D 097, the affidavit of Iyer, which is an additional statement according to him. It ends on page SB1D 102.
Is the signed one, the
is
one that is commissioned.
Properly commissioned and is signed on the 31st of August 2012.
That is correct. So this statement could not have been one that Advocate Jiba would have had, as she states in 24.5, as a statement under oath that was placed before her at the time she made the racketeering authorization, because it was signed after that, after the 17th of August. and it appears that NJ, I beg your pardon.
Thank you, Madam Chair. I'm advised that the issue of the prosecutor can be clarified. The public prosecutor, who's referred to as a second respondent in the review application, is actually Advocate Maema, and that appears in bundle B5. B-oath 1342 and 1342 and 1343.
Thank you, Council.
And thank you, Madam Chair. And that closes the issue of the internal memorandum.
Thank you, Council. We will adjourn to resume tomorrow morning at 9 o'clock.
Thank you, Madam Chair.
We adjourn.